Greetings, everyone. My name is Ricardo. We are still receiving new guests, new participants. So we are going to wait 1 or 2 minutes while everyone is arriving. Thank you. I see a hand raised. This is Ricardo speaking. Raja, do you have a question? We haven't started yet, just to clarify. You can use the chat if you have any question.
No problem, no problem. I'll wait.
Thank you so much.
You're welcome.
The number of participants is still growing a little bit, so we're going to wait 1 more minute and we will start at
ما زال يتوافد المجموعة من الحضور. الساعة الآن 5 دقائق، سوف ننتظر حتى الساعة 5 بعد الساعة 3:05.
Okay, so this is Ricardo speaking again. I work as a protection officer for the UN High Commissioner for Refugees. Usually we are co-sharing the facilitation of these webinars with our colleagues from International Disability Alliance. I am speaking today from the office of the International Disability Alliance, and we have a workshop. So our colleague Ham Josefian asked me if I could share or facilitate this webinar so she can cover the workshop, so we can divide and conquer. So I'm going to co-facilitate today alone, but we have 2 colleagues as well from the UN Refugee Agency who will be sharing in this 3rd webinar additional information on the core mandate of UNHCR, and we will see the themes and persons with disabilities. So how the core mandate interacts with persons with disabilities or intersects. But before, I would like to hand over to our colleague Tanya, who will explain some of the accessibility features that we have for the webinar. Tanya, over to you.
Dear all, my name is Tanya. I'm going to briefly explain some of the technical features of today's call. This webinar is being recorded. There is international sign interpretation, captioning in English, and language interpretation in French, Spanish, and Arabic language. A CC button on the bottom of your screen will enable the closed captions. If you need captions in the external window, The link is in the chat box. The interpretation button on the bottom of your screen, presented as a globe, will allow you to access specific language channel. Please choose your channel that you will follow throughout the meeting. The participants do not have an option of opening the microphone and video. Should you have questions, kindly leave them in Q&A section. Our team is monitoring the chat box and will try and respond to questions during the event where possible. We request all speakers to kindly keep to times and keep their cameras if not speaking. We are asking you that you speak slow enough for the interpreters and captioners to follow. Thank you all and have a good meeting.
Thank you, Tania. This is Ricardo speaking again. Today's webinar is part of a series, it's the third webinar in a series of consultations and information sharing webinars on the joint collaboration between the International Disability Alliance and the UN High Commissioner for Refugees. We started with the first webinar on interacting with human rights mechanisms, including, but not limited to, the Committee on the Convention on the Rights of Persons with Disabilities. We learned how we can cooperate in doing confidential submissions, informing together these submissions, as well as shadow reporting, and what are some of the opportunities to advocate as well and to support direct access, for example, to the committee through individual procedures. In the second webinar, we discussed about an upcoming opportunity for participation at the global level, which is a Global Refugee Forum. It will take place within a year from now in 2023 at the end. And it will be an opportunity, again, to advocate with member states for better inclusion of refugees, stateless persons with disabilities, as part of the global implementation of the Global Compact for Refugees. We will share more information on these webinars. We have recordings and as well some meeting notes that will be circulated. And today we will discuss about the core mandate of UNHCR. In the next webinar, next week, taking the opportunity of the 16 days of activism against gender-based violence, we will have colleagues sharing experiences as well in prevention and response to gender-based violence for persons with disabilities, women and girls with disabilities, and experiencing in programming. And finally, there will be a last consultation after the International Day on Persons with Disabilities on the 3rd of December. And this will be more of an open space based on all the information that has been discussed about the human rights mechanisms, Global Refugee Forum, protection response, international protection response, etc. What would be 3 key asks that you would have for UNHCR, member states, your own organizations, 3 commitments that we could move forward for the next year? This is the idea of this webinar series. I'm going to share in the chats later the contacts or the links for registration for the upcoming webinars, and I encourage you to register. Even if you can't participate, you will receive then the briefing notes and you will be able to influence on those consultations. But without more introduction, I would like to then enter into the discussion of today, the topic. We have 2 colleagues, one per one of the key sections of UNHCR that are working on key aspects of the mandate of the agency. And the first one is Mathilde Crépin, who will be speaking about refugee status determination. She is herself a refugee status determination officer and will speak about the process of establishing refugee determination status and how these asylum procedures intersect, or what are the situations that persons with disabilities may experience, and how to address as well some of the barriers they may encounter. Our second speaker will be Marcela Rueller, who is a statelessness officer, and she will speak about situations of statelessness when persons do not have a nationality, and how as well disability among them can be one of those factors, and what are the consequences. We will have then a Q&A session, so questions and answers. There is on the bottom of the chat, or the Zoom screen, you have a Q&A tab, and you can write there your questions if you would like to speak as well, to ask for the opportunity, and then we will go into a discussion. So without further ado, I'm going to share my screen and give the floor to our colleague Matilde. Let me just check that you can see this slide in full screen. Matilde, can you confirm?
Hi, Ricardo. Yes, that's perfect.
Great.
I can see
Okay.
everything.
Okay, so over to you. Thank you.
So hello, everybody. Good afternoon or good morning, depending where you are. I'll be, so my name is Matilde, as mentioned by Ricardo, and I'm working for the Refugee Status Determination section at UNHCR. And I'm going to speak today about refugee status determination and the process, and how we can get to apply for asylum and to obtain refugee status or not. So Ricardo, you can go to the next slide. I don't see this.
Is it visible? No, it doesn't change.
I see two slides actually with the notes.
Okay, very strange.
I don't
Okay,
see
so it's sharing the other slide. Sorry, I'm going to start sharing. Sometimes it happens. Apologies for that. Let me see. Okay, so I'm going to screen share. I will share screen 2. Probably is going to work better. Does it work better now?
Ah, yes, better.
Yes, and if you want to see 2 slides, just press escape so you can see other slides as well. Thank you.
Okay, no, that's perfect. So today, as mentioned, we're going to speak about refugee status determination. Firstly, I will explain to you, so there's going to be a part that will be a bit more theoretical. I'm not going to dwell on this one, but just to explain to you the definition, what is the definition, and who is a refugee, the refugee definition. There are actually several definitions. There is a global universal definition, and then there are some differences per region. So I'm going to explain this to you. And then we're gonna spend a bit more time on discussing the procedure. So it's going to be much more practical and concrete to see how do we get concretely when someone applies for asylum, how do we get refugee status. Just a few words on the picture, first of all, that you can see on the slide. In this picture, you can see a small girl who's shaking hands with a staff, UNHCR staff, obviously, because she wears a visibility vest. So both are shaking hands. And this is a picture that I like to use to represent the refugee status determination process, because it represents some form of collaboration between two persons. So this is what RSD should be. Basically, it's not an entity, so UNHCR, for example, or state asylum system that receives asylum applications and that just adjudicates. It's not how it works. It has to be a collaboration. So the entity that receives the asylum application has also to support the asylum seeker in presenting their asylum application, and has to make reasonable accommodation so that the asylum seekers can present their claim, can explain their story as much as well as they can, basically. When you're an asylum seeker, whether or not you have disabilities, you're often in a situation of vulnerabilities, or you might have specific needs because you've left your country. Often, it's not always the case, but in an emergency situation. So you don't necessarily have taken your documents. You might be in a situation of stress, post-traumatic stress. There are people with disabilities that could be physical disabilities, that could be intellectual disabilities. So there's a variety of conditions, and individuals, when they apply for asylum, are often in need of support. So this is what the RSD procedure is. This is a collaboration. The receiving entity receives the asylum application, but also has to provide reasonable accommodation for the asylum seeker to present their claim. So firstly, we're going to speak about who is a refugee. And maybe you can go to the next slide, Ricardo. Yeah, so who is a refugee? The universal definition of a refugee is enshrined in the 1951 Convention relating to the status of refugee. So this is a universal convention defining who is a refugee. Briefly, there are a few main criteria. So on this slide, there are 5 criteria. The fourth one, I'm going to start with the fourth one, which is actually the starting point. In order for someone to be a refugee, first of all, they have to have crossed an international border. So individuals who've been displaced within their own countries, they're not refugees, they're IDPs, they're internally displaced people, but they're not considered refugees. Then there are other criteria, 4 main criteria, let's say, to be recognized a refugee. First of all, the person who has crossed the international border has to be in a situation where they cannot go back because they have 1, a well-founded fear, 2, of being persecuted, so of facing persecution if they go back to their country. I'm going to speak a bit more about this notion, but the notion of persecution, in essence, relates to a form of harm that is sufficiently serious to amount to persecution. It's not any form of harm, it's not any harm, it has to be serious enough to amount to persecution, in few words, but I'll speak a bit more about this. 3, they have to have this well-founded fear of being persecuted for 5 different reasons. It could be one of these 5, or cumulatively it could be several of these reasons, but at least one. For reason of race, so that could be their ethnicity, someone who is an ethnic minority, for example. Religion, so someone who is at risk of persecution based on their religion or their absence of religion. Being also not a believer could create great risk in certain contexts for a certain person, or for reason of nationality, or political opinion is the last one you see on the slide, but I'm mentioning this because as the last one, I would like to mention members of particular social group. Members of particular social group, it's a vague concept that seems a bit vaguer than the others, but it's often a concept that can be quite relevant for persons with disabilities when they applied for asylum. I'll explain myself later on. So this has to be, the risk of persecution faced by someone has to be based on one at least of these 5 reasons. And lastly, the individual who claims asylum has also to demonstrate that they cannot avail themselves to the protection of their country. Meaning if, for example, they are at risk of persecution from a non-state agent, just giving you an example, for example, someone who's at risk of domestic violence from their spouse, we have to consider, can they seek protection from the police, for example, in their country? Can they seek protection from the state authorities in their country? If they cannot, then they might be refugees, might be entitled to refugee status. So these are the main criteria for the universal definition of a refugee. If one doesn't meet this criteria, there are other criteria. Ricardo, can you go to the next slide, please? So these are the other criteria. We have broader, what we call broader definition. These are regional definition. They're not universal. The broader definition were drafted because we came to an understanding that the universal definition was somehow too narrow for certain context at a certain time. This issue came up particularly during the 60s, 70s, during the decolonizing wars, where we thought that the universal definition would not necessarily fit the situation of people who would escape generalized violence. So as you would notice, the definition that I just described is very individualized. It's based on someone who is at risk of being targeted for persecution. But there were contexts, considering certain contexts, where people would just flee very broadly general form of violence. They would not necessarily demonstrate that they're at risk of being individually targeted, and nonetheless, we thought they were in need of protection. So two definitions were drafted, one in Africa, in the Organization of African Unity Convention, and one in the Cartagena Declaration. It's not a convention, it's a declaration, but it's the declaration that adopted a broader definition for countries in South and Central America. I'm not going to read them because I don't want necessarily to dwell on that, but what you have to keep in mind is that these broad definitions, they're roughly similar. The wording is slightly different, but basically they relate to objective situation of generalized violence, massive human rights violation, or events that seriously disturb public order. So objective situation in a country rather than focusing on the individual circumstances of a person. These broader definitions, as I said, are applied only in some regions, so in South America, Central America, in Africa. For UNHCR, we also have an extended, we don't call it an extended definition, we call it an extended mandate. But this is the idea is roughly similar, whereby we will look at this general, like if we consider that an asylum seeker doesn't meet the individual criteria to be recognized a refugee, then we will look at this broader criteria to see if we can recognize them just based on the country situation. These are the criteria to be recognized as a refugee. So let's see how these criteria can apply to persons with disabilities. Ricardo, can you go to the next slide, please? Okay, so yeah, I can see it. Disability and asylum, how is that relevant for persons with disability? There's a lot to talk about, the way we interpret the criteria for persons with disabilities, but I'm just going to give you just a broad understanding of the situation and how few examples on how this can apply to persons with disabilities. So firstly, we can consider that disability per se, either a physical disability or a intellectual disability or a mental health condition, it can be a ground to for refugee status, meaning it can be a ground for persecution. There are some examples, I'll mention a few to you, but some examples whereby persons with disabilities are being targeted in their country because of their disability. So in this situation, we would consider that they fit, I mentioned to you the 5 grounds. So ethnicity, religion, political opinion, nationality, and membership of a particular social group. So we would consider that in this situation, they would meet the criteria of membership of particular social group. And the social group would be persons with disabilities. This is the case. So we came across some example in Nigeria, for individuals, we mentioned that in a previous webinar, I think, for individuals who have albinism, they are being targeted specifically because of their albinism and the stigma attached to it. The risk that they're facing is usually quite high. They're facing discriminations, but they're not only facing discrimination, but they're facing risk of being killed in ritual killings, basically. Discrimination is not in itself persecution. We don't consider that when people are facing discrimination, they are facing persecution. It has to be, the threshold has to be a little bit higher, as I mentioned a bit earlier. However, accumulation of persecution and other forms of harm can amount to persecution. So in the case of persons suffering from albinism, usually the risk that they're facing in their country is serious enough, clearly, to amount to persecution. Another example I could give you is in Iraq. It was the case a couple of years ago. We had some reports on the situation in Iraq, whereby individuals with physical disabilities, for example, in wheelchair or crutches, would be targeted for kidnapping because of their perceived vulnerability. And the perception that it would be easy basically to kidnap them, they would be kidnapped for ransom. So we consider that they would be at risk of being individually targeted for persecution, and they could be recognized based on their membership to a particular social group. So this is one of the ways that disabilities can be relevant when we assess whether or not asylum seeker meets the criteria to be recognized as a refugee. There are also scenarios whereby individuals with disabilities apply for asylum, but the risk that they're facing is based on another of the grounds that I mentioned. They don't claim asylum based on their disability. They can be at risk of facing persecution based on their political opinion, religion, ethnicity, something completely different. However, they're disabled. So they have an extra vulnerability that can be actually taken into consideration throughout the legal analysis. This could be the case, for example, when we assess the notion of persecution. I mentioned earlier that persecution, discriminations don't amount to persecution, but persecution is a notion that we have to assess. There's no universal definition of persecution, so we have to assess it on a case-by-case basis. And we have to assess this against the individual profile and circumstances of an applicant, of an asylum seeker. So for certain persons who have disabilities, because they have this extra vulnerability, then the impact of discrimination can be much greater. So if you take into consideration the disabilities and how discrimination impact their daily life, then you can argue, although discrimination is not considered to amount to persecution per se, in the circumstances because of the extra vulnerability faced by this person, this may amount to persecution. So this is just an example to show you how disability, even if not a ground per se to apply for asylum, is nonetheless an element that we can take into consideration when we assess someone's claim. So now this was more like for the theoretical part of it, so that you know who is a refugee and how this is relevant for persons with disabilities. Now I would like to go to the most practical part. So concretely, how does someone apply for refugee status? Yes, thank you, Ricardo. Firstly, who is responsible for adjudicating a claim? So when someone has left their country because they're facing some form of harm, they went to another country, they've been displaced, and they think they cannot go back to their country. They want to stay in that country, country B, let's say. They left country A, they want to stay in country B. How can they claim asylum?
¿Cómo pueden solicitar
There are
asilo?
different scenarios. Some countries
En algunos
have
países
signed the 1951 convention and some
tienen
haven't. The countries
hay
that have
una
signed the
convención
1951
ratificada en
convention are
1951
supposed to have put put in place.
Excuse me, this is an international sign interpreter here. Matilda, your sound is cut off. We have another channel interfering.
Sorry.
So we missed the last half minute.
Okay. Should I go back to
tenemos
who's
algún problema
responsible for
con la
adjudicating
conexión.
asylum
Podría
claims?
volver al problema de adjudicación de asilo.
Can you hear me well now?
¿Me pueden oír bien ahora?
We still have interference from the Spanish channel.
This is Ricardo speaking. I don't have that interference. I don't know if it's an issue of selecting interpretation channels.
Let me know if you want me to start over for this.
Díganme si quieren que vuelva a empezar con esta diapositiva.
Is it okay?
¿Está bien ahora la interpretación? ¿Se puede oír la interpretación?
Yes, I think it's okay.
Yeah? Shall I continue? Okay, maybe I'll start over on this slide so that it's clear for everyone. So I was saying we have to look at who is responsible for adjudicating asylum claims. When someone leaves country A, they go to country B. Where do they go? Basically in country B to lodge an asylum claim. So there are different scenarios. Some countries have signed the 1951 convention, some haven't. Those who have signed the 1951 convention are supposed to have put in place an asylum system. So then they would look, the asylum seekers would go to the state authorities. There should be some committee responsible for adjudicating asylum claim, and they will have to file an asylum application to be registered by the authorities of this country. In some countries that have signed the 1951 convention have not managed, for various reasons, to put in place a solid asylum system. So in this situation, UNHCR is supporting them. So that's what we call joint or parallel asylum procedures, where the asylum application would be received by UNHCR or by the state authorities with the support of UNHCR and adjudicated within this parallel or joint asylum system. More relevant for our mandate, countries that have not signed the 1951 convention that don't have any asylum system in place at all. So let's say when an asylum seeker comes to country B and the state authorities have nothing in place to adjudicate their claim, then they will turn to UNHCR, directly to UNHCR's office, and they will file an asylum application there, and UNHCR will be in charge of organizing the reception of these people, registering them, and considering their claims. So in this case, let's see the different steps of the process. Ricardo, can you move to the next slides, please? Okay, so there are different steps. I'll walk you very quickly really through these steps. First, you have, as a new asylum seeker, you have to be registered. So UNHCR has to organize the reception of asylum seekers, register them, meaning they will take down the basic biodata to understand your profile, who you are as an asylum seeker. And after that, issue some documentation for you to be able, ideally, to stay in the country. It's not always that easy, but when you have an asylum seeker document, certificate, the ideal is that this will give you the right to stay in the country until your asylum claim is being processed and considered, until either you're recognized as a refugee or final rejection of the claim. After being registered, issued documentation, this is one of the key elements of this process, is the RSD interview. So an appointment will be set in order to have a refugee status determination interview. In this, during this interview, the interviewer, so someone from UNHCR or a state employee in a state asylum system will ask questions to asylum seekers in order to understand the reasons why they left their country, why they fear returning back, different circumstances. These interviews can be quite long. They can take sometimes several hours, or there can be several interviews. It's because we try to gather as much information as possible in order to understand the circumstances of the persons who seek asylum and whether they meet the criteria that I just described. You will notice that there is a heavy component on the oral procedure. So what matters, what we're trying to do when we're conducting an interview is to really create the condition for someone to articulate their experiences, their life story as much as possible, as best as possible. After there is the interview, then based on the information that was collected, a committee, so it can be eligibility officers or some people that are called reviewers that work with them, will assess the life story of the person and consider whether they meet the criteria. They will draft an RSD assessment in order to recommend whether this person can be recognized a refugee or not. Then if they recognize a refugee, they get a refugee card, end of the process, end of the RSD process. If they're rejected, they have a right to appeal. The same process can start again. There could be an appeal interview based on the circumstances, and their claim can be reconsidered on appeal. So throughout this process, what is very important is the notion of meaningful participation. As you see, and as I just mentioned at the beginning of the presentation, this is actually a collaboration. It's not just an asylum seeker coming and proving their claim. It's also the adjudicating authority trying to accommodate as best as possible this person so that they're in a situation that is conducive and favorable for them to explain their life story. It's never easy. Again, whether or not you have disabilities, it's never easy. And when you have disabilities, it can be even harder. When you have physical disabilities, first of all, there has to be reasonable accommodations for person to articulate their claim. So for that, we have a document that we call the Refugee Status Determination Procedural Standards that lay out all the different measures that need to be taken during the procedures. And there's mentioned throughout the document, there are mentions on what reasonable accommodations need to be made to ensure that person with disabilities could meaningfully participate into the process. It's not enough to have a process in place. This process has to be meaningful for them to participate. So there are physical accommodations such as the reception centers. They have to be adequate to receive persons. We have to have ramps, for examples. They have to be sufficiently wide. I'm just giving an example in the RSD procedural standards. It is specified that this accommodation have to be organized by the country operation. It's more on a case-by-case basis, but to ensure that everyone with physical disabilities have access to this process. We need to ensure that if needed, there are sign language interpreters, for example. So these are the types of accommodations that could be important and that could be taken into consideration. Information dissemination is also something that is important. We need to ensure that information and counseling about the procedure is disseminated in a way that is accessible to everyone. So again, then it will depend on the operation and the country organizing the reception to decide what is relevant, but there could be a variety of platforms to be used to disseminate information. It could be videos, different types of leaflets, but we have to ensure that the information is disseminated to the widest audience possible, including persons with disabilities. There is a particular chapter in this RSDPS, we call them Refugee Status Determination Procedural Standards, dedicated to person with mental health condition and intellectual disabilities. We decided to dedicate a chapter only for persons with mental health condition and intellectual disabilities, because as I just described the process, you can understand that this is something that is very much based on the individual's ability to articulate their story. As I said, it's something that can be difficult for anyone, regardless of being disabled or not, especially for individuals who've undergone trauma. And when you have a particular mental health condition or intellectual disability, even more difficult, even more complicated. Of course, we rely also on written information. All relevant information is something that we take into account. But in most cases, people don't have documents to prove their claim, to prove their life story. If they have that, that's good. But again, they have to be able to explain orally what happened to them. So this chapter for persons with mental health condition and intellectual disabilities lays out all the different measures that need to be taken into consideration. Firstly, we need to have trained personnel who are able to understand different mental health condition or intellectual disabilities. There's different measures that can be taken, such as a support person or designate a support person or a legal representative that can help support the asylum seeker in articulating their claim. They can be referred to mental health specialists. There's a variety of measures, as I said, and RSD interview can be also accommodated for them. So as I was mentioning, sometimes it can take hours. This can be very heavy for persons with such condition. Just giving an example, we can then make shorter interview or several interviews with more breaks. I mean, these are all elements that really need to be factored into the procedure when we're facing with person with mental health condition and disabilities. I mean, there are more elements. If you want to refer into detail to this chapter, you can go. It's available online. It's called the RSD procedural standards. We can give you the reference, and it's unit 9. It's unit 2.9 of the RSD procedural standards. And the key elements, I mean, the key notion that is being taken into consideration is this meaningful participation of applicants. So this is how we're trying as much as possible to accommodate persons with disabilities, and this is where the challenges are being factored into the procedure. There is, lastly, I'm going to say the last point on this and then move on to very briefly what's happening in state asylum systems. There are also training that are being developed, particularly to interview persons with trauma, mental health conditions, what are the different techniques, how we can formulate the question to ensure that their meaningful participation. This is quite important. Lastly, so Ricardo, if you can move to the last slide, please. What do we do in a state asylum system? What I just described, these procedures that are being enshrined in the RSDPS are procedures that are UNHCR's procedures. So this is just for UNHCR's operation when we adjudicate asylum claims. In state asylum system, I was saying the countries that have signed the 1951 conventions, they are the ones responsible for adjudicating claims, not UNHCR technically. So they have a relatively similar process. This is a process that is based very much on the oral statements of asylum seekers. The RSDPS and the different accommodations that are being recommended to make the RSD procedure accessible to everyone, including persons with disabilities, do not bind the states to be used as a guidance for them. And it's strongly encouraged that they refer to them when they develop asylum procedures. Maybe just a last point, and then I'll be done on durable solutions. When we're in the UNHCR RSD mandate context, resettlement is one of the durable solutions that is available to refugees and persons with disabilities. It's not necessarily automatic for all persons with disabilities, but it can be taken into consideration when we're trying to apply for resettlement for certain persons. When we're in a state asylum system, durable solutions, the main durable solution is actually integration within the country. It's not necessarily resettlement to another state, because if this state has signed the 1951 convention, they would look for durable integration in that country. Hopefully with reasonable accommodation and access to rights for all persons with disability within that country. And this is where I will stop. I think I was quite long already, so I'm happy to answer any question later on.
Thank you, Matilde. This is Ricardo speaking again. There are some questions that could link very neatly with what you were mentioning before, or right now, in terms of durable solutions. And I'm going to read, and I understand it's not specifically related to your work, but we could, in any case, outline some answers. And that question from Charles Choll is it possible for persons or for us who live with a disability to be resettled? And clarifying that he's studying in a university, etc. Maybe if you could outline two lines in terms of resettlement, and as well maybe mention other complementary pathways as regards to studies as well, which is not sure how much we could give this information, but at least mentioning that there are other colleagues who work on this, and this could be a theme for another webinar in the coming period. Over to you, Matilde.
Sorry, I was looking
yes,
for
go ahead.
unmute button. Yes, thank you, Ricardo. It's a very relevant question. Indeed, I'm not an expert in resettlement. We have a special department and colleagues dealing with durable solution, because as you may know, resettlement is just one of the durable solutions that we look for asylum seekers. However, what I know from resettlement is that when you're a refugee with disability, no, okay, let me put it differently. Resettlement, there are different criteria on which someone can apply for resettlement, and disability is not per se one of these criteria. There are physical and legal needs, for example. I don't know them by heart. I think I wrote them. Medical needs. So it's not disability, but it could be medical needs. Women and girls at risk. There's different criteria. If disability, if you're in a country where there is sufficient accommodation, it could be in the country for persons with disabilities, so you can live normally in that country as a disabled person, then your file will not be considered in priority for resettlement, because you might be able to live in that country, so to have access to local integration. However, it can be taken into consideration if you cannot. So what I'm saying here is that actually this will be considered on a case-by-case basis. It's not because you're disabled that you automatically have a right to be resettled, but this is something that will be considered depending on where you are, the kind of disability you have, the resettlement countries, what kind of resettlement scheme they have. And as Ricardo mentioned, resettlement is only one of the durable solutions. There are other durable solutions. There are other types of complementary pathways. For example, a pathway linked to education, that UNHCR can facilitate. Family reunification can be other types of complementary pathways. But again, I'm not too much an expert on the durable solutions. We have colleagues that work on that, and I'm sure they have a lot to say. That could be a great topic for another webinar, surely.
Thank you, Mathilde. And I shared in the chat, there is a handbook focusing on integration as well, but applying to resettlement and disability, and some of the factors, not for the identification and of the durable solution, but rather what has to happen next, right, in terms of accommodation throughout, reasonable accommodations, accessibility, etc. Issues as well on access to social protection in country once people is resettled or integrated. So inviting you, and then there is a tool that was developed in the past on resettlement for refugees with disabilities that I pasted as well, and includes as well information such as what Mathilde mentioned in terms of what would be the submission category, acknowledging that there's no a list of submission categories that include disability, but there could be other type of categories. And what is important as well is to gather information on how disability intersects with all those submission categories, and then consider accommodation measures, etc. I will then only add, there's more questions now. We may go through some of them in terms of what happens is very similar as well to when refugee is less about the procedural standard, but when there are human rights violations against refugees with disabilities, and who would be accountable. Maybe Mathilde, would you give a try on that answer as well?
Yes, on who would be accountable for human rights violation, right? Oh, that's a broad question. UNHCR doesn't hold perpetrator of human rights violation accountable. Accountability happens in front of court of justice, basically. So the main entity responsible for holding perpetrators of human rights violation accountable is the authorities of their country. So the justice system, the police is responsible for arresting them, bringing to a judge. So this is the justice system. At the international system, but that's not refugee law anymore. We're more looking into international criminal law, but we have international criminal court also at the international level, only for certain types of crimes that, again, it's not necessarily domestic law, but that's not a UNHCR. UNHCR, if you will, just to simplify it, is helping the survivors of human rights violation. The ones who hold them accountable, it's different entities. We don't do it.
Thank you. There is an interesting question. I will answer maybe Rashid Hassan in terms of agencies intended for persons with disabilities at a governmental level. So this would apply not only to refugees, but to persons with disabilities at large, including refugees, though. And usually in some countries, there's more and more a ministry line on persons with disabilities. Sometimes it can be a Secretary of State. Sometimes it can be part of social welfare. It is a line that is being more and more developed in social development and is very relevant for as well refugees with disabilities, because initially any person with a disability under the jurisdiction of a state should have equal opportunities, at least to certain levels of rights. Then there are discussions in terms of protection services that are addressed in particular to citizens of a certain country, but that is a question for debate as well at a global level. But usually, yes, the idea would be to find social welfare social protection stakeholders, and sometimes it can be through as well referral through health stakeholders or health services or social welfare community-based organizations who can give information on available services and protection schemes for persons with disabilities in country, and then assessing whether those are accessible for persons with disabilities or not. But I would like to go to two questions that are similar, that are have been shared with some level of detail in terms of risks of threats. So I'm reading the question from Dula at the end of the Q&A, and there's a person with a disability can apply for as an asylum seeker, so for international protection. And the question is, would the threat has to come from the entire community, or only could apply as well for one person who is posing a threat to the person with a disability? That is an interesting question because it could apply, in my opinion, as well to gender, to other type of grounds, but it is an interesting question. And then there would be more questions in terms of what would be the conditions in home country, but as well the possibilities for return. Would you like to expand a little bit in that questions and those questions?
Yes, sure. So, and this is very interesting point. To make it simple, a person, an asylum seeker can apply for asylum or can be granted refugee status, even if only one person poses a threat. It doesn't have to be a lot of person. It doesn't have to be an entire community. It doesn't have to be the whole state apparatus. It could be just one person. What we will have to look at, if it's the case, if it's just one person, can the refugee, the asylum seeker, find protection within their country? I was mentioning the case of domestic violence, and Ricardo mentioned the situation for a person with at risk of gender-based violence. I'm mentioning this because we have these claims quite regularly. We see it's relatively frequent. Then one person can claim fear from only one person of their family, one spouse, for example. Then what we will look at is, can they find protection within their own country? No, maybe not. In certain country, they cannot find because of the law discriminating against women, or there is no efficient police protection. The same for persons with disability. Then you'll have to look at, if they are targeted by one person only, can they find protection? If the state apparatus is not efficient, doesn't provide efficient protection, then they might be entitled, depending on the circumstances, they might be entitled to refugee status. Doesn't have to be whole community. The next questions were, how does refugee and asylum seeker ensure that the host country has better conditions than their home country? Well, that's very tricky for them. Usually, sometimes they don't. People often leave their country because they've been forcibly displaced by some condition, and they don't necessarily choose the country they find refuge in. If they can choose and define a country that is convenient for them, even where they have family, that's great. But again, that's not always the case, and sometimes they don't have the choice. And this is where the difficulties arise, and the question of durable solutions are being raised. How to find a durable solution for that person if it's not local integration, meaning if they cannot stay in the host country because the conditions in the host country are not great, then what do we do? Again, resettlement is an option. Then let's find another country or other complementary pathways. We will look at other durable solutions. Can the refugee go back to his own country after some time when the situation is better? Yes, they can. But in that case, if they go back to their country with a view to resettle there, because the situation gets better for them, they might face what we call a cessation procedure, meaning we would consider that they don't need international protection anymore. so their refugee status might be seized. This is voluntary repatriation or voluntary return when the situation is better in the country, is also one of the durable solutions that we can be looking at. But if they go back to their country, then they run the risk to have their status seized in the initial asylum country or the host country. But they're free to decide what they want to do, depending on the situation. Yes.
Thank you, Matilde. And there's two questions. I don't know if you could as well take them quickly in terms of women. I understand having the possibility or time to represent themselves in other countries. And maybe I will ask this person if could clarify the question in terms of, in principle, there would be equal capacity, right? But maybe the question from Mohammed as well, in terms of a procedure of accelerating asylum claims, where people are required to fill the PF1 form and given a shorter date for interview, which may be a problem in terms of people requiring more time to access, and as well issues in accessing legal aid assistance. I don't know if you would like to address this question or maybe type in the chat.
I can try to address quite quickly. So for okay, going to the second question. So basically, when a person with facing some trauma or some vulnerability, he is being called for an interview in an accelerated through an accelerated procedure, probably, or it's too quick for them to be interviewed. What can we do? I understand. I hope my understanding is correct. Well, RSD procedural standards, you can go back to this document, and the RSD procedural standards say that accelerated procedures can be used in order to protect individuals when we consider that we need to adjudicate their claim very quickly because they need quick protection. However, depending on their mental health or their situation, accelerated procedure might not be adequate. And this should be very clearly taken into consideration. And if it has not been in a certain UNHCR operation, the asylum seekers can raise that themselves in the interview. When we conduct an interview, we provide counseling at the beginning of an interview, and we advise that there is a right to postpone the interview if the applicant doesn't feel fit for the interview or has an issue. And this should definitely be brought up to the interviewer and taken into consideration in the procedures. Depending on the protection environment, there can be possibility to refer to a mental health specialist before the interview, for example, or to take any relevant accommodation. But this has to be brought up, and this should definitely be taken into consideration during the procedure. If acceleration is not adequate, the procedure shouldn't be accelerated.
Thank you, Matilde. We are going to, I'm very sorry, but we will have to move to the second speaker, Marcela. I see as well that there are questions in terms of documents expired. I would like to stress that we should differentiate what are questions more at the global level or understanding about processes, and we are, of course, fully aware of the difficult situations that some refugees with disabilities and without disabilities are experiencing, but asking them as well to address these questions at national level. We can only support to a certain level of, in terms of passing these messages, and is more on systemic problems than on individual cases that we can answer. Okay, so thank you for your understanding. I would like to pass the floor now, thanking Matilde for your presentation and answering questions, to Marcela to share about statelessness situation. So I'm going again to share the screen and just checking that is visible. I will launch the presentation. Is it okay, Marcela?
Yes.
Okay, thank you. Over to you.
Thank you very much. And hello, everybody. Good morning, afternoon, evening. My name is Marcella Rauler, and I'm a statelessness officer with the statelessness section at UNHCR Geneva. And I will speak on another part of UNHCR's mandate, and that is on statelessness, because UNHCR is mandated by the General Assembly to identify and protect stateless persons and to reduce and prevent statelessness, or rather to support states in these areas. So in the next 30 minutes, I believe we have 30 minutes, right, Ricardo? Or
yes,
checking.
around
Or
25. Yes.
25 minutes, okay.
Thanks.
Can you go to the next slide, please? So we'll cover quite a bit of ground. First, we'll quickly go over the key concepts on statelessness and the right to nationality. Then causes of statelessness, the impact of statelessness, both on individual and societal level. Then I will talk about the legal framework to address statelessness at international level, solutions to prevent and resolve statelessness, and then finally, I'll give a quick overview of the major situations of statelessness. We go to the next slide. Well, let's start with the key concepts. So first of all, citizenship and nationality, they're often described as, well, they're normally understood as meaning slightly different concepts, but in international law, these mean the same thing. So I will also be using the two terms interchangeably. Yeah. So what is nationality? And nationality is the legal bond between an individual and a state. And it can also be described as a form of membership that results in rights and duties. And when we think of rights associated with nationality, it is, for instance, the right to enter and reside in a state, but also political rights, such as the right to vote or to hold public office, and the right to diplomatic protection. In some states, nationality also comes with certain duties, and then particularly the duty to perform military service. And the right to citizenship or the right to nationality is a right in itself, but by accessing or by having a nationality, people often also have access to many other rights, or turning it around, nationality is often a requirement to access other rights. And because of this function, the right to nationality is also often described as the right to have rights. Article 15 of the Universal Declaration of Human Rights clearly stated that everybody has the right to a nationality. And this was later also reiterated in many other human rights instruments. Go to the next slide, please. Thank you. So, sorry, I had an issue with my headphone. To understand statelessness, it's important to understand how nationality can be acquired. There are two key modes of nationality acquisition. It can be based on family links. So when a child is born, nationality can be acquired based on the nationality of the parents. This is also referred to as jus sanguinis. But also later in life, somebody can acquire nationality through family links, and that is, for instance, due to marriage to a national. And somebody then automatically acquires that nationality, or after a couple of years, and that can then also be linked to residence in the country. And the second mode of nationality acquisition is through territorial links. So again, if a child is born, nationality is then acquired based on place of birth, and this is called jus soli. And also here with this mode of acquisition, nationality can be acquired later in life, and then it's based on long-term residence. And while there are these two distinct modes of nationality acquisition, in reality, most countries, most nationality laws include both jus sanguinis and jus soli provisions. And that is in order to prevent statelessness in exceptional circumstances. And you can say roughly that for for the first category or the first mode of nationality acquisition, so through family links, that is more common in countries in Europe, and in the Americas, you see more nationality laws that are based on territorial links. We go to the next slide, thank you. So who is a stateless person? What's the definition of a stateless person? This is provided by Article 1 of the 1954 Convention relating to the status of stateless persons, which provides that a person who is not considered as a national by any state under the operation of its law. So that is the definition of a stateless person. There are 96 states parties to this convention right now, but also for countries that are not party to this convention, this definition applies. And that is because the definition was deemed to be part of customary international law. A few things important to note here. Most stateless people are born stateless, but people can also become stateless later in life. And we'll look at that more closely when we talk about causes of statelessness. Also, a person can be both a refugee and a stateless person. Mathilde before spoke about refugee protection. So, you know, refugee status comes with a set of rights, and the same goes for statelessness status. So a person can have both statuses at the same time, even though refugee status gives slightly more protection than statelessness status. And a person like a stateless refugee, their statelessness can be both a cause and a consequence of their displacement. So just to provide an example, for instance, in the case of the Rohingya from Myanmar, for them, their statelessness was one of the causes of their displacement because they were deprived of their nationality and faced persecution and other discrimination. And this led to their displacement. And but in other circumstances, a refugee can also lose ties to their country of origin if their displacement is long-term. So in that scenario, a refugee becomes stateless, or like statelessness is a consequence of the displacement. However, most stateless people have never left their country of birth. And that's very important to note because many people, when they first hear about the concept of statelessness, they think of undocumented migrants. And that's actually an undocumented migrant is rather maybe at risk of statelessness, but is not stateless. And most people have actually never left their country of birth. Could we go to the next slide, please? So I already briefly introduced the concept of being at risk of statelessness. So this is kind of a category in between. This is often the case, people who do not have documentary proof of a nationality, they may be at risk of statelessness. So they may have an entitlement based on the law because they were born in a country, for instance, and nationality law stipulates that due to birth, somebody can obtain a nationality. But because they have lost their documents, their nationality documents, they can no longer prove that they have that nationality. And especially if they are part of, for instance, a minority, or they are displaced, they're migrants, they may have difficulties to establish their nationality. Then we speak of people being at risk of statelessness. So groups that are maybe at particular risk. Disabling my headphones. Can you still hear me?
Yes, thank you, Marcela.
So groups that may be at particular risk of statelessness are migrants, border populations, minorities, nomadic people, victims of trafficking. Here we go to next slide, please. So let's now look at the causes, the key causes of statelessness. A very important cause of statelessness is discrimination. So this can be on the grounds of ethnicity, religion, gender, or disability. On the next slide, we'll look more closely into that. Then the gaps and conflicts in nationality laws, state succession and transfer of territory, and lack of birth registration and documentation can put children at risk of statelessness. Now let's first look at discrimination. Can we go to the next slide, please? So, like I already mentioned, discrimination is a very important cause of statelessness, and this is already evident when we look at the composition of the stateless population worldwide, because 75% of the world's known stateless populations belong to a minority group. And sometimes, in some cases, the discrimination is stipulated in the law. So the nationality law itself already clearly excludes certain groups, certain ethnic groups, for instance. But more often, it's rather how a law is implemented. So this can be policies, but also just practices by individual officers, for instance, who apply the law in a discriminatory way, which can then mean that certain ethnic groups or religious groups are excluded. Also, discrimination on the grounds of disability can lead to statelessness. It's actually the most, if you just look at the nationality laws, what's included in nationality laws, it's the most prevalent form of discrimination. But this form of discrimination is mostly included in provisions relating to naturalization and not often to provisions on the acquisition at birth. So for instance, you would see nationality laws that say that somebody needs to be of sound body and mind in order to be eligible for a nationality. Now, it's very dubious how this would be implemented, but there is a clear risk there that this could lead to exclusion to nationality based on disability discrimination. But we do not have clear figures on the implementation of these types of provisions. But also just in the procedural requirements to access a nationality, a person with disabilities may face obstacles. And then we may think, for instance, of language requirements, like somebody needs to demonstrate that they can speak a language, or that they need to be fit to work. Those kind of requirements can present obstacles which may prevent persons with disabilities from accessing a nationality. Can we go to the next slide, please? Thank you. Also, gender discrimination is a very important form of, or a very important cause of statelessness. And that is because in 24 countries, women are not allowed to confer their nationality to their children on an equal basis with men. And this can lead to statelessness in case the father is stateless himself, or if he is unknown or he has disease before the birth of the child, or because he, for instance, doesn't recognize the child. And because the mother then cannot confer the nationality, the child would end up stateless. There's also another form of gender discrimination which can be found in the nationality laws of 50 countries. That is that women do not have equal rights with men to acquire, confer, change, or retain their nationality. And this mostly relates to conferring nationality to spouses. So for instance, men can confer their nationality to their spouse after marriage, while women cannot. And of these two forms, of course, the first form is more likely to lead to statelessness than the second form. Can we go to the next slide? Also, conflicts between or gaps in nationality laws can lead to statelessness, and I'll explain this. Like we previously saw, there are these two modes of nationality acquisition, and these can conflict in a way
that leaves that can leave a child fall through the cracks. For instance, if a child is born in country 1, where nationality is acquired based on the nationality of the parents, but the parents are not from that country, they're from country B. But then we look at country B, and the nationality law of that country only confers nationality based on birth on the territory. So now there's a clear gap, because the child supposedly has links to 2 countries, because the child was born in one country but has parents from another country. But because of the nationality laws, actually the child does not have access to either nationality. So then we speak of a conflict between nationality laws or gaps in nationality laws. Now, in order to prevent statelessness in these situations, it's very important that countries, that states introduce certain safeguards, and so provisions in their nationality laws in order to prevent statelessness from being passed from one generation to the next. And one of these safeguards is the following. This is the most important one, that children born on the territory of a state should acquire the nationality of that state in case they would otherwise be stateless. So this would prevent, like in the situation that I sketched, then the child would get the nationality of the country where he or she was born. We go to next slide, please. Also, state succession can lead to statelessness. So when we speak of state succession, I mean that, for instance, a state breaks up into 2 or multiple states, or when part of a territory is, for instance, annexed by another state. And this can lead to statelessness in case the nationality law of the new state does not recognize that person as their national. That can be because of discrimination against particular minorities, but it can also be an oversight. It can be that, that certain groups were left out. And this has happened a few times in the past, that large stateless situations were created due to the disintegration of states. So for instance, with the breakup of the USSR, we saw that up to this day, there's quite a number of people that are still stateless because they were not recognized by any new state. But also, for instance, with the breakup of Yugoslavia, there was the same situation. Could we go to the next slide, please?
Thank you. And just reminding, we have around 6 minutes, so maybe if you could wrap up in case there is any question. Thank you so much.
Yeah.
Sorry
okay.
for.
No worries. I'll go a bit faster. Then we'll go to the next slide, because this may be not the most important one. Birth registration. Actually, go to the next slide, which relates to this topic. I'll cover this. Yeah, so I already said that if somebody lacks proof of a nationality, a person may be at risk of statelessness, and that can be, for instance, if the birth of a child has not been registered. And that is because in a birth certificate, or a birth certificate includes key information that provides evidence of a child having ties to a country. So, for instance, it includes it includes information on the place of birth, and it also includes information on who the parents are. So, regardless of what mode of acquisition the country applies, this birth certificate would provide proof of what country that child has ties to and what nationality the child is eligible for. So that's why birth registration is very important in order to prevent risks of statelessness. Can we go to the next one, please? Yeah. So the effects of statelessness can fall both on the individual and society at large. So it depends on the context, but generally persons who are stateless may have problems accessing education, employment, but also maybe excluded from social welfare, financial security, and housing and healthcare. And they may have, or they also may not be able to vote, are constricted in their, or restricted in their movement, and have risk of being detained. Can we go to the next slide, please? But also their impacts for society as a whole, and that is because if large parts of the population are stateless, there's a risk of marginalization, alienation, and this can lead to instability and conflict and displacement, and also overall it may lead to lower standards of living. And this is an area that we're trying, as UNHCR, we're trying to push out this message as much as possible, that statelessness is very much also a developmental issue and really needs to be addressed. Can we go to the next slide, please? Okay, yeah. Can we go to the next one? Just trying to go to the most important parts. Okay, so there are two important conventions that you should be aware of in terms of legal framework on statelessness. There's the 1954 convention relating to the status of stateless persons. This is kind of the sister convention of the 1951 convention relating to the status of refugees. They were actually also drafted at the same time, but the 1951 convention ended up coming out earlier, clearly by its name. What this does, this convention, it provides the definition of a stateless person, and we've gone over the definition, and it provides certain rights that stateless people are entitled to. And that is, for instance, employment, housing, travel documents, and facilitate naturalization. And just as within the 1951 convention, there is no specific obligation for states to establish a determination procedure, but there is an implicit obligation, because without a procedure, it's not possible to identify who is stateless and who should, in fact, benefit from the protection. Then could we go to the next slide? The 1961 Convention on the Reduction of Statelessness. This convention has 78 states parties, and it provides a number of key safeguards to prevent statelessness at childhood and also later in life. The three key ones are listed here. The first one I've already mentioned, that is to grant nationality to a person born on the territory if the person would otherwise be stateless. Second one is grant nationality to a foundling found in the territory. And finally, grant nationality to a person born abroad to at least one national if the child would otherwise be stateless. So this, there are many human rights instruments out there that just provide for the right to nationality generally, without stipulating what nationality a person has a right to. And this convention goes a step further and places certain obligations on states that are party to this convention to grant nationality in these specific scenarios if the child would otherwise be stateless. Could you go to the next slide? I think, yeah, there are a number of regional instruments as well. I won't go into detail. Yeah, very quickly. So UNHCR in 2014 launched a 10-year campaign to address statelessness by 2024. And that is, I should say, the campaign was accompanied by a global action plan to end statelessness. And this includes 10 actions for states to take. And on the next slide, it provides the 10 actions. And I won't go into them because of lack of time, but perhaps the presentation can be shared, and maybe also this global action plan if of interest. And you can read a little bit more about yeah, all the solutions to statelessness. It's quite an interesting document, just kind of as an introduction to the topic of statelessness, I think. I think I'll leave it there, just in interest of time.
Thank you, Marcela. Yes, and we run out of time. Apologies for this. We took more time. There's always this issue, right, on more understanding as well and more concerns around refugee issues, while statelessness is still an area where we are exploring more and more the intersectionality with disability. I hope everyone found this introduction important, relevant to the work. If not, please look at documents related. We will share the presentations and maybe Marcela as well, the study on discriminatory grounds and statelessness, because I think that is very important and where you can find more information on the interaction with disability. And with this, I think we are going to close the webinar. Thank you so much, Marcela. Thank you, Matilda, as well. Thanks, everyone. Please register for the upcoming webinars as well. And remember that on the 5th of December, we will have another opportunity as well to share questions and as well recommendations for upcoming consultations and work with UNHCR. So sorry for not being able to address your questions. For basic or social protection and statelessness questions, there's a question now being answered by Matilda. I don't know if you would like to answer very quickly online. In 30 seconds, maybe as well. Matilda, would you like to address? Or Matilda, Marcela? Because it
sorry, I didn't see it. Which organization is mainly responsible for the basic social protection of the stateless person? That would be the state. So states are responsible for the protection of stateless people, also to identify them. And the role of states is simply to support states in this. But in the end, both the protection and the grant of nationality can only be done by states.
Thank you, Marcela. Well, with this, we are going to close the webinar, acknowledging as well the work of interpreters, sign language, and different languages. Thank you so much for keeping us together. And thanks to the International Disability Alliance for organizing this webinar as well. See you in the next webinar within a week. Over to you and have a nice week. Bye.